we will start with Jean-Francois Bellis, who is the managing partner and the founding partner of Van Baalen Bellis. Van Baalen Bellis is one of the most prestigious competition law and regulation and trade law firms in Brussels. And they are a true inspiration also to independent law firms, I must add. In fact, very many years after I found ELIG Attorneys at Law, I felt that perhaps subconsciously I was kind of impressed by Van Baalen Bellis, because this color of our law firm is exactly the color of Van Baalen Bellis as well. We found out that that's the case when we were having lunch some 4 or 5 years after the incorporation of ELIG Attorneys at Law. I had the privilege of working on the Microsoft case with Jean-Francois, as I did with Ian Forrester. So I was the attorney assisting Ian Forrester on the famous Microsoft case. And as Ian likes to say, after the hefty fine to Microsoft, I fled to Turkey. Jean-Francois and I then maintained our contact, and he is involved in most of the very interesting cases, as you have seen in the previous session as well. So who better to talk about settlement procedures under EU law, challenges and opportunities? He was also gracious to offer that he might wrap it up in about 20 minutes, and with gratefulness, I'm inviting him to the floor. Thank you.
Thank you, Gönenç. It's true that I feel that we have many things in common with Gönenç firm, including the colors, though you will see that ours is a slightly different shade of green. So indeed, Gönenç, well, I met him for the first time in the Microsoft case, where we were indeed working on different parts of the case. Ian and Gönenç were working on interoperability. I was working on tying, and indeed Gönenç left in the middle of the court proceeding. But since then we have continued to work together, and whenever we have an issue of Turkish competition law, we turn to Gönenç. It has been mostly merger control issues, and I have to say that we have always been very happy to work with him, and he's really our man in Turkey for competition law. So I'm going to make a presentation which will be limited to 20 minutes, though the number of slides that I have is, well, 36, 37 is more than 20 minutes, but I will compress my presentation. But first, I would like to have the slide. Yes, okay. Thank you very much. Basically, and the settlement procedure that I'm going to talk about is the settlement procedure in cartel matters. So basically, our two presentations, Terry's and mine, will be focusing on cartels. And, well, I have to say that I had been waiting for a long time for something like the EU cartel settlement procedure, because I had been sitting in so many hearings in cartel cases where practically all the defendants were leniency applicants, so the infringement was not contested. And so the only issue that was still open was the amount of the fine. But this was the only issue that could not be discussed, because especially in the old days, it's a bit different today, the Commission statement of objections would not contain any information about what kind of fine it wanted to impose. The Commission would indicate that there would be a fine, but that was all. The Commission even did not feel obliged to warn the parties that it would consider aggravating circumstances, such as ring leadership, to increase the fine of a particular defendant. So this was, well, the elephant in the room. everybody was wondering what the fine would be. And the defendants would find out on the fateful Wednesday when the Commission would adopt its decision, and then the parties could see how the fine was computed, and very often would find that there were mistakes or inconsistencies, and this gave rise to, well, essentially unnecessary appeals which could have been avoided if the parties could have engaged in a discussion about the fine with Commission officials before the decision was adopted. But the settlement procedure was introduced only in 2008, while the leniency system was introduced more than 10 years earlier. So why this long wait? And the essential reason is that the Commission wanted to change its finding methodology so as to introduce a methodology which would be more predictable, based on objective factors such as the value of sales affected by the infringement, the duration of the infringement, because what the Commission wanted to avoid was a bargaining process, where companies would discuss about the level, negotiate the level of the fine with the Commission. Well, I'm prepared to give you 50 million. The Commission says, no, it's not enough. I want 150. Okay, we settle at what, 100, at 100. This was the kind of discussions that Commission officials wanted to avoid. And I still remember a conference in which Mr. Mehta, who was the then head of the anti-cartel directorate, saying, well, I don't want to engage in any bargaining because then the Commission's anti-fraud unit called OLAF would be constantly monitoring my bank account. And indeed, in some countries, there have been problems of corruption in the competition sector. And the Commission wanted to avoid any situation where there would be a negotiation which would be unprincipled, just based on the ability or the willingness to pay the fine. So this new finding methodology based on objective and predictable factors was introduced in 2006. And so this is, I think, a precondition for a settlement system in an administrative enforcement model. You need to have a predictable basis so that the discussion about the fine is constrained by clear principles, clear rules. Now, a second precondition for such a settlement procedure to work is to have a judiciary who is relatively tame, who will be happy to just apply the fining guidelines, who will not try to use its unlimited jurisdiction to write its own fines. Because if there is the possibility to go to the General Court and have the fine computed on a completely different basis, hopefully more favorable basis, then of course there is no incentive for the defendants to agree on the level of the fine with the Commission. And a third precondition also for such a system to work is that there be a sufficient level of trust between the parties, their lawyers, and the Commission, because Commission officials who engage in those discussions take some risks. And as we will see in some recent cases, sometimes this creates situations which turn out to be very embarrassing for the Commission, but I will come back to this in a few minutes. So, moving quickly, basically the settlement procedure is a procedure in which there are benefits for the two sides. For the Commission, the main benefit is that the procedure will be faster because there will be limited access to the file, no hearing, the use of one language, which would typically be English, well, shorter decisions, shorter statement of objections, which will be settled and settled decisions, settled statement of objections, and normally no appeal. There is a right. The right to appeal is maintained. So companies which settle with the Commission may still appeal, but this is rare, and normally they should not appeal because they would have agreed to the facts, they would have agreed to their liability, and they would also have agreed to the level of the fine. But as we will see, appeals are sometimes taking place. So these are the benefits for the Commission. Now, for the companies, there is a visible benefit, which is a reduction in the fine of 10%. But this is only the visible part of the benefit. The main benefit is that the parties are able to engage in a discussion, not a negotiation, a discussion, with the Commission about the parameters of the calculation of the fine, the duration. Is it 5 years? Is it 6 years? About the value of sales. Are sales for this or that sub-product, sub-market covered? Is the discussion continuous, or is the discussion, the cartel, limited to certain discussions of specific contracts? These are all kinds of issues which can be discussed, and depending on the conclusion of the discussion, the fine may be significantly higher or lower. So these are the invisible benefits of this procedure for the parties. So I will refer you to the slides for these technical questions, and I would like to focus more on the question of whether this procedure is working. Well, as you can see, there have been 17 settlement decisions thus far. Proportion of settlement cases is increasing. As a result, also, you have more cartels decisions than before. And the level of fines has not really increased. So this is for the picture of how this procedure works. Now, in the 5 or 10 minutes left, I will discuss the situations where the procedure has not worked as expected. And you have basically two types of situation: the so-called hybrid settlements, in which some parties refuse to settle or engage in settlement discussions and then withdraw from the negotiation, which of course is a problem for the Commission, because it needs then to adopt a formal decision according to the normal procedure against the non-settling companies. And then you have also situations of failed settlements, so settlement negotiations that start and then stop. And then also something which the Commission did not anticipate, appeals against settlement decisions. First, the hybrid settlements. Well, you see the list on the slide. And what you can see is that the number of those hybrid settlements is increasing. Now, as I said, a hybrid settlement is not really great for the Commission, because the Commission needs to do all the work to adopt a decision against the non-settling parties. So basically eliminating many of the benefits of the procedure as far as the Commission is concerned. Still, the Commission is prepared to use this type of procedure, having to send a message to companies that they will not be able to hold out the process, that the Commission is prepared to go after them in the normal way if they get out, if they move out of the settlement negotiation. So it's more, I think, to send a message. But if you have more and more hybrid decisions, that I think will throw doubt about the usefulness of that procedure for the Commission. Now, when you have an hybrid settlement, there is a problem, because the Commission has settled, and of course we'll have seen with some sympathy, the companies that have agreed to make its life easier by basically working inside the limits of the process. And now, as to the others, the ones who do not settle, the Commission must treat them impartially. They should not be treated worse than those who have settled. And the only difference between the settling companies and the non-settling companies would be this discount of 10%, which the non-settlers would not obtain. But, well, things are not always so simple. And in a recent case in which, and here the slide has been bypassed by event, there was a decision by the Ombudsman this week on this case, a bit embarrassing for the Commission. In the euro rate derivatives case, which was a hybrid case, Commissioner Almunia made a statement to a committee of the French Senate saying that we'll go the full distance in the probe of Crédit Agricole, JP Morgan, and HSBC. Crédit Agricole brought a complaint to the European Ombudsman alleging that such statement displayed some bias. And the Ombudsman, the EU Ombudsman, agreed this week and said that the Commission should apologize for the statement made by Mr. Almunia, because indeed it suggested that the Commission would not treat Crédit Agricole in an impartial manner. But of course that statement was made in a case where there had been discussions with the parties about settlement, so where parties had agreed to their liability and to their fine, but of course the Commission was required to forget about all of that and to treat Crédit Agricole as if nothing had happened. Not easy. Also, another case where the company complains that it was penalized for having refused the settlement, and that its fine was not just 10% higher, but it was 25% higher, because the Commission regarded in a more critical way the quality of its cooperation, and so gave it a lower leniency discount as that which than the one which would have obtained if it had settled the case. And of course the Commission is saying that, well, settlements are discussions which are not binding until there is a final settlement agreement, and the Commission is entitled to change its mind. Then you have also the situation of involving failed settlements, so settlement discussions that start and finally do not succeed. And well, the slide on the that you see describes an example, the smart card chips case, which was a case where, in fact, there were discussions, there were doubts about whether the infringement really could be proven. And of course, this for me is an illustration of the type of cases where the settlement procedure should not be used. The settlement procedure should be used in cases where ideally every single defendant is a leniency applicant, where there is no doubt about the existence of the infringement. This is not a procedure for cases which are contestable, which was apparently true for this one, and also true for the yen derivative case, which in my view involve discussions which, well, may be a form of fraud, but I still have a hard time to see how these discussions restricted competition between the banks, but that's another matter. And then a final problem. the settlement process is supposed to yield to a situation where the defendants have agreed to their fate, and even though they have the right to appeal, they are not going to appeal. And here we have a case, Société Générale, in which a settling company complains about the level of its fine, about how it was computed. Now, so it will be interesting to see what will happen in that case. But of course, a company which does this runs the risk that the court then might increase its fine. If it finds that the appeal is unjustified, that it will increase its fine by 10% because the company had settled, and in the settlement it agreed on the maximum amount of the fine, then is disputing that amount. Does that justify then the loss of the 10% settlement discount, which is another issue which will be at the heart of that appeal. I have only a few minutes left. I refer you to the following slides, which I think will be shared with the audience, showing that essentially, yes, companies are benefiting from the settlement. There are less aggravating circumstances being used. The duration of the proceeding tends to be lower. So yes, there are many invisible benefits to this process. And of course, one benefit also of the settlement process for companies which are concerned about private actions, follow-on private actions following a finding of infringement by the Commission, is that the settled decision tends to be extremely sketchy, so providing less information to potential plaintiffs. And also, of course, all the settlement submissions are confidential and are not accessible by private plaintiffs, which is another hidden benefit, or not so hidden benefit of that system. So this brings me to my 20th minute, and I will stop here. And of course, we can discuss this further in the question time. Thank you for your attention.
Well, one of the many wonderful things about a very experienced litigator is that if you say 19 minutes and 36 seconds, he will speak for 19 minutes and 36 seconds. So thank you for that 20 minutes presentation. Not that we have asked him to shrink it in there, because it's invaluable what we're hearing from him, but he kindly offered, Jean-Francois Bellis kindly offered to present it that way. Settlements are extremely close to the heart of the Turkish practice. As some of you know, there is an effort for a new law that is before the Grand National Assembly, the Turkish Parliament. I am the board of directors member of TÜSİAD, as some of you might know. TÜSİAD is one of the biggest, perhaps the biggest industrial organization, industrialist and businessmen organization in Turkey, accounting for more than 80% of all registered employment in Turkey. And as such, we act also in the Grand National Assembly, trying to put forward the business views on certain matters. I also head the competition law group of TÜSİAD. I do see members of our group in this room. And the settlement issue is very close to our hearts. And there's a kind of a carrot and a stick in there, because I have always been a huge proponent of the settlement procedures. I have published at the prestigious competition journal of the Turkish Competition Authority, which I wholeheartedly recommend to all of you to look into, in 1999. Not my piece, but into the journal. I think the journal is coming along really well, and it's a great contribution of the Turkish Competition Authority to the competition law thought in Turkey. And in 1999, I was a huge proponent of it. Now, just as of March 25th, I will be delivering a speech next week. I will be delivering a speech that there is a good and evil of settlements and settlement-like procedures in formative competition regimes. So I am, in more recent years, starting to think that the budding competition regimes, or you couldn't call the Turkish regime a budding regime because we've been doing this for 18 years, but formative competition law regimes that are still getting their entire act together and their muscle together might be losing something also through settlement regimes. You do gain on efficiencies, but you might be losing lines of precedent. You might be forcing counterparts to easy settlements with the threat of administrative monetary fine. We are using Article 9 letters a little too liberally in the recent years. Article 9 letters are akin to the Article 11 letters in Europe. And unfortunately, the Turkish administrative courts do not recognize that Article 9 letters are a subject to judicial review, which is a huge problem for us. What it in turn means is that to the extent the Turkish Competition Authority decides to handle a matter not through a full-on investigation, which would grant the due process that kicks in at that point in time, and decides to handle it through 3 written forms of defense and 1 verbal oral hearing, if they were to be amicable about it, and if they were to say, I'm sending you a letter, comply with this or else, then the parties cannot take this to a court and say, I have received this letter, I don't want to be subject to a full investigation, but there is a threat of punishment in there, so this is a final decision, do subject this to a judicial review. That does not go through at the moment. So when looking into settlement issues and even leniency issues, I think, and that's where I am heading to the next speech, we think we should start also thinking about what these technologies are doing to formative regimes. I had recently published in an international article the thought that the new US merger guidelines are not helping the formative regimes either. It's brilliant that the US is switching that direction, getting rid of bright lines that are available in merger control review and wanting case-based economical analysis. But for jurisdictions where there aren't that tool of case-based economical analysis, perhaps the bright lines are helping. I'm not suggesting that the US should think about what this would do in Turkey, but what I am suggesting is that formative regimes should not be too quick to embrace all of the mechanisms of regimes that have matured their mechanisms through ample discussions and experiences.